she also, maybe just to say a few words, that she studied law. So she's also a lawyer at Galatasaray University in Istanbul, in Turkey. And she also holds LLM degree in European Union law from the same university, and she also registered with the Istanbul Bar Association, but she also had an experience of being a research assistant, and that she is in the registry of the European Court since 2003. So I should go, I'm sorry if I missed anything, but I'll give the floor to you. And if you also want to add something from your CV, please do so. But once again, a real pleasure having you tonight, and thank you really for having time to meet with us and to explain how the decision by the European Court is adopted, and what you as lawyers look, and how students who are attending this course on feminist judgments, basically what they should look at and focus on when they think how the decision can be also rewritten, having in mind this gender perspective. So the floor is yours.
Thank you, Ivana. Thank you very much. First of all, apologies. I was supposed to speak last week, but I was really sick, and you may hear me coughing from time to time. Secondly, absolutely, it's Friday evening. We're all super tired, so I'm really not going to take a lot of your time. And I certainly don't want to lecture you. First of all, yes, I was a research assistant about 20 some plus years ago, but I'm not a professor like your professors, so I don't have this competence of, lecturing in a very professional manner. So what I would really suggest that we do is really a dialogue. We're also not so much, not numbers. It's not like a 20-30 classroom setting. Online teaching is already quite, I would say, not very pleasant experience, because you don't really have that kind of relationship with the people that you speak with. So what I suggest is that we have a dialogue. How I will start is, first of all, whatever I say, it's in my own capacity. That I really have to underline. It doesn't bind the court at all. It is true that I have been working at the court since 2003. That does not necessarily mean that I know everything. But if you do have questions, I may be able to find ways, and if not, at least I can get back to you later on with your response. Now, what I thought would be interesting for you is really to give a very general introduction of how things work at the court, like the kitchen aspect of things, and then maybe mention a couple of recent cases which I thought were quite interesting for you, perhaps, and then maybe we can really discuss things that you find interesting before we close the session. I think that would be a good way to go. Perhaps the first question is, does any one of you have been to the court before? Did anyone had like an internship? Are you all lawyers? It might be interesting for me to know. No one is speaking. There's only one person with the video, so Irina, start.
I can say I'm a lawyer. I'm currently representing the bank in Serbia, but I didn't have a chance to be at any international courts, just these Serbian courts only.
It's not bad. It's not bad to be in the Serbian courts. It's already something in the... Yes, Irina.
You would have absolutely fresh ears with me. I'm not a lawyer. I enrolled in PhD studies in international law, but my background's nothing about it. It's international relations and then commercial thing. So I'm switching shoes right now. And for me, everything you would say, I would appreciate to hear.
Okay, that's great to know. Pressure is down immediately. Una?
Yes, well, I am a lawyer and I visited once the European Court of Human Rights, but just a visit, and I met a judge and we had a little talk and we went around the building. But of course, on a daily basis, I get to see Serbian courts as Xenia, but that's not much interesting as the international ones.
Oh, I would not say that. It's quite interesting. It's a very important work, national courts. Huh? Don't underestimate the job that you do representing clients before national courts. And our only male candidate I see, Saiful Islam. Hello.
I hope that Saiful can hear us. Not at the moment.
Okay.
No?
Well, when you are able to get back to us, you give us your feedback. That'd be lovely. Okay, so basically, then I can really be very, very basic with this. So the court, European Court of Human Rights, it's based in Strasbourg. It is an international court. It is a court which is part of this whole human rights machinery of the Council of Europe. The Council of Europe is an international organization, and like many of the international organizations that we're all aware of currently in the world, United Nations, European Union, etc., OECD. Oh, that's a lovely cat. Sorry, I'm getting completely. Oh, he's beautiful. It is based. It is a reaction to the political situation which happened after the end of the Second World War. So the Council of Europe was really, really formed because there was a huge trauma in Europe, and you would know that better than anyone else, being a political scientist, I would say. And there was a need to say, okay, so what do we do? How do we kind of organize ourselves in a way which would ensure that there is peace in Europe and therefore prosperity and all the rest which comes. And so Council of Europe was formed, and it formed itself on three basic pillars: rule of law, democracy, and human rights. And basically, it's under this pillar of human rights you would find the European Convention on Human Rights. The Council of Europe has huge number of treaties which deal with everything under the sun, I would say, except for defense, because that's part of its competence. But you would be able to find a lot of, so the European Convention on Human Rights is a more general human rights treaty. But you would be able to find specialized treaties. For example, the one which is very relevant for you is, of course, I don't need to say, the Istanbul Convention, for example, which is this convention which concerns violence against women and domestic violence, and it is monitored by a monitoring body which is called Grevio. So you have ECRI, for example, and the convention which concerns discrimination issues. So you have a bunch of different conventions and treaties, and the European Convention is just one of them. But the major difference is it is protected by a court, by an international court. And that is, I think, one of the major differences compared to the rest of the treaties, some of which are extremely forward-looking and which deal with very important issues like minorities, like cultural heritage, etc. But the convention is the one where you have a very efficient, I would say, and I'm not only saying that because I work there, but it is a very efficient international court. It is a very efficient international court because it has the possibility of what we call a direct application by individuals. And that is something which is quite rare. We do have different systems of human rights protection, which I will not go into, which I'm sure that some of you already know. And if you have issues, I mean, Ivana is much more capable than me to explain all of that. But it is a court where an individual person who feels that they have been wronged at the national level, so they went to the national courts, and they lost the case, they have direct access to this court. And that's why this court is really important, and it's very precious. What is essential and important also about this court is that when you're applying to this court, unlike some national courts, you don't really have any court fees. That's also important to know. So the application process is very simple unless you get a very expensive lawyer to do the application for you. So it's a very simple process. The building is in Strasbourg. There is a whole historical thing which I'm going to not go into because so that we don't waste time. But basically, the system is constantly changing. Sometimes it is including new rights through treaties which come into new play, which are the protocols. So the protocols to the convention, they bring new rights into the convention, which didn't exist initially. Or there are, again, through protocols, changes to the convention in the way that we work. And part of the reason of why there is all this ongoing changes is because the system is adapting to the environment. That is to say, it started off as, I would say, a relatively, let's say, harmonious, heterogeneous group of countries. And then later on, when, for example, the wall came down in the end of 1990s, then there was the need to incorporate different member states from Eastern European bloc, for example, and that created a whole bunch of caseload, which was huge. And already by that time, the court was struggling, and at the time, the Commission with the caseload coming also from Turkey. So it's a code which adapts to the situations, and it adapts its working methods throughout the history. So if you look at very old cases, you may find differences in the way that we do things. And it's what I would consider a very agile court. Why? Because compared to some courts, economically, it's not a very rich court, in the sense that the budget comes from member states. The member states decide on a budget. But unlike the other, I would say, court in Europe, which is the European Court of Justice, which has a lot of budgets, huge amounts of money, we don't have that. So the court has to be very practical in the way it deals with things. So that's just to give you a general idea of how work and thing is done. So, for example, we had a meeting with the Court of Justice, and they were like explaining how many people were working in their library, and their library is like, I don't know, there were like, I think 50 people, and our library consists of 3 people. So that kind of gives you the difference and the change. It is a modest court. So when people come to visit, especially from national courts, and they come to visit the judges' offices, they are shocked by how modest the judges' offices are. It's not huge. They have 3 windows. That's like a big luxury for us, because the building was built like 30 years ago, and it's very old. We're usually very cold. It's not well heated, so that just gives you a heartwarming introduction into the building. So things don't work all the time. It is a code which I would say in many ways you are not going to feel the sense of the grandeur comes from the subject matter of the code, if I may say, and not because it's a very flashy, fantastic building or whatever. It really comes from the fact that it deals with very, very interesting, sometimes very sad, very tragic cases. And it is there really to make sure that the human rights is respected in the member states, and the system is there, and it is protected, I would say, and it is upheld by the member states. That's also another thing that I think is interesting for you to know, especially those who are not lawyers. Although the cases are against member states, because the cases are against a member state because that member state failed to comply with some of its, or the allegation is they failed to comply with some of its obligations. The state is not like an enemy. It's not the other side. It is a real relationship and dialogue with the member states, and especially with the national courts. That's very, very important. Superior courts of member states, and the court always has a dialogue between themselves. Why? Because for the court and for the court's jurisprudence, the primary actors which have to implement the convention are the national courts. So the court it says, I'm an international court, and I have a kind of like a distance vis-a-vis what's happening in the daily life. We are bound by certain procedural rules. For example, it means that when an application comes before us, and we communicate, and I will explain very briefly afterwards the stages of how it works. You are bound by the documents which are there. You can ask questions and receive other documents, but it's not like a domestic court where it's very rare in our system to have a hearing. It's usually reserved for the grand chamber cases, and even if when you have a hearing, it's not like a hearing like in the national system. Each side has like a certain period of time when they have to speak, and then there's like questions and answer, but it's not like a domestic system. So you are remote. You are remote from the essence of where the situation happened. And that is why it's very primordial and it's very important that the domestic systems, that the domestic courts apply the convention in a manner which is in accordance with the court's case law. And as long as they do that, then the job of the court, our court, the European Court of Human Rights, is easier, because then you have less cases before us, and also there is less chance of sense of feeling, for example, sometimes that you may feel that you're not fully aware of all the facts of the case, because I don't see the applicants don't see me. I cannot, for example, imagine a situation which concerns, let's say, a rape victim. In the domestic criminal courts, the domestic courts have the possibility to have the rape victim in front of them, and they see that person's demeanor, they see how that person speaks or cries, and the physical gestures, and on the basis of that, the domestic court judges, in addition to, of course, all the other evidence which is there, but nonetheless, we're all human and we are affected by, the relation, I would say the jests and the kind of the words and all this approach that is done. So they have that kind of possibility to see the demeanor of that person and maybe judge or feel whether or not that person is telling the truth, for example. That's not the case for the court, our court, because we have everything in written format. So unless you have a hearing and unless you have an applicant which comes physically to a hearing and speaks for 10, 15 minutes, you don't actually meet anyone. You are in file. So that is also something that is important for you to know when you are going to work on this very interesting topic that you do regarding revisiting and rewriting feminist judgments. It's important to understand the context of how this work is done by the judges. So it's a written procedure, and I think that also changes a lot of things, because then it depends on what is written there and how it is written there. Sometimes you receive an application, for example, and you can have a sense that there is more to what is said there, but you cannot make up things which are not there. And sometimes you can see things, for example, and you will say, well, this application would have been perfect for this particular complaint, but the applicant is not complaining about that. The applicant is complaining of something completely different. And it is not for the court to widen the scope of that. And sometimes there are times when the court readjusts the complaint, but it doesn't readjust the complaint. But what it does is sometimes it does examine it under another provision, but only if this is possible. That means that if only under that provision in the domestic system, the applicant has argued that point. So that's very important to understand, that sometimes there are limitations to what the judges can decide on, because you are limited on the basis of the complaint of the applicants, on what they said at the domestic proceedings, how they pleaded their case, both domestically and before us, and what kind of evidence they provided on both sides. So this is very important to understand, that carré of how things work. In terms of how it is organized inside, maybe it is important to mention. So we have 46 member states. We were 47, unfortunately, because one member state aggressed another member state a couple of years ago. So Russia is the country in question. They were kicked out. And I'm speaking very openly here, so please do not record, but and I'm speaking in a more informal manner. But yes, they were ceased to be members of the Council of Europe, which I thought was very unfortunate for all the Russian citizens and everyone else in Russia. But nonetheless, this is what happened. And so we now have 46 member states. And so which means we have 46 judges, because each member states have one national judge, a judge which is elected in respect of that member state. But again, that doesn't mean that the judge which sits there is there to be kind of the advocate of that member state. On the contrary, a judge is elected on the basis of their competence, and the national judge for us simply means a judge which actually knows the domestic legal system. because you can understand that if a person is dealing with a case against Serbia and they have no understanding of how the Serbian law works, it will be very difficult for that judge to explain to the colleagues and everyone else why certain things are were accepted like that, or what does that mean, or what that law provision means, etc. So the national judges are elected. They are there because of their own competence. They're elected by the Committee of Ministers, which is a political body in the Council of Europe, and they're fully independent. And then they come here. They have a 9-year mandate, and then they are flooded with cases, basically, on their desk. The moment they arrive, they are flooded with cases. The judges sit in 5 different sections. And each section is theoretically, and I'm saying theoretically because sometimes there are realities which do not make this possible, but theoretically the idea is that for each 5 section, judges are distributed in accordance with their national, I would say their legal tradition. So you would have, for example, some Nordic judges in different sections, or, for example, on the basis of gender balance, so female, male judges, more or less. Again, there I'm saying theoretically because we have around 15 female judges so that means that you can't really have a full equal 5 sections. But theoretically, at least some female judges, they all are kind of distributed in different sections, as well as there is a kind of like an unforeseen, again, idea of distributing judges on the basis of also their background, because what is also rich in the system is that you have different, I would say, different backgrounds. So you have judges who are from academia, and so they bring this academic, I would say, fresh air, very much following what's happening in the academic world, very much, I would say, enthusiastic moving forward. And then you have judges who were judges before, and they bring all the knowledge of how to, I would say, that they have an immense knowledge of how to adjudicate cases because they were judges in their own domestic system. And so they would be able to, for example, say, and again, here I'm speaking very openly, they would be able to, for example, the judge would be able to say there's a case of medical negligence, let's say, and the judge would say that if in their domestic system this judge was a specialist of this, then that person would be able to say, well, in these type of cases, these are the kind of points that are really essential that we need to know, for example, because they come with that kind of experience. So we have 5 sections where all these 46 judges are there, and then the I would say the bureaucracy which is behind all of this, the court, is the registry. So the registry is not like so much like the registry of the national courts. These are basically a group of people, myself included, and we're around 800 right now. So it's relatively big bureaucracy, I would say. People who are either lawyers, they could also be, there are a lot of assistants who do paralegal work and other secretarial work. We have translators because they have to translate into the 2 official languages sometimes, especially the grand chamber cases. We have, of course, our IT department, which deals with all the background dealings with the IT related issues that we would have. So we have the central office. So you have different people, different profiles, basically in this building, which Una has already seen, and which I did not very describe it in the most flattering manner, but it is a beautiful building, obviously. So we're all in that building. And the role of the registry is really to provide assistance to the judges. So that's the kind of the general role. What happens in practice is the following. So you're at your national system, and you. So let's go, for example, Xenia had a major case against a private company because I think, Xenia, you said you were working for a bank.
Yes, I'm representing the bank against.
Okay, so you would have cases of people not paying or something
Yeah,
like that,
yeah.
let's say, or they were doing something major. So Xenia represented her bank and against this big company which took a lot of loans and did not pay back, etc. There's a whole bunch of things happening, and let's say that the bank is a private bank and not a state bank, and in the end, there's a whole proceedings in the domestic system, and Xenia loses all of her cases there, right? But she believes, okay, there's really a problem here. We didn't have a fair trial because the commercial court did not listen to all our witnesses, did not take into account some of our documents. The other guys, for example, the other guy's lawyer knew the judge. They were best friends. They played squash. I don't know. All sorts of things can happen. And therefore, I think there's a problem under Article 6, and I want to bring this case to the court. So what she would do is just basically literally compile all the documents that she has in the domestic, that she has submitted to the domestic courts. And of course, if she already programmed to come to the court, then she would, for example, if she's going to the Constitutional Court of Serbia, she would already rely on the same arguments and say, voila, there was a issue with the independence of the judge. I asked the judge to recuse himself. He didn't recuse himself. Voila, and this is a problem of independence of the court, and let's say that the Constitutional Court says, no, that's not the case. I think everything went well. You lost the case. Voila, closed. The case is closed. It's at that moment that she prepares everything. And what we have now is an online application form. So we are trying to move into this paperless setting. So she would fill out the online application form, put everything, and then just post it. And that's how an application is done. And when that application comes, it comes to what we call the central office. So these are a bunch of people who speak impressive number of languages, because obviously Serbia is a member state, so we have people from Serbia, but it could be that an application can come in another language, and it's more complicated if it's not a member state language. But nonetheless, we do arrive sometimes finding people, for example, who speak Arabic or who may speak Chinese. And the central office's job is basically to shift this file. So they would look at the file and they would look at, say, okay, so this is against Serbia. So I'm going to send it to the unit, the national unit, which deals with Serbian cases. So each registry is organized in what we would call the national units. And these national units have lawyers which work which are lawyers from that member state. Why? Again, because you need to have someone who understands the national law. Tout simplement. It's a very simple thing. So when I was recruited in 2003, I hate to say the year, but when I was a young lawyer and I was recruited to work in a unit which dealt with Turkish cases, because I was a lawyer which was practicing law in Turkey. So I knew the Turkish law. So that's how I ended up here. So you have the Serbian unit, and the Serbian unit, the lawyers which work there, then they receive this file, and what they do is they first and foremost check to see we have certain procedural rules, like every national court does as well. We have rules, which there's the 47, which says, for example, you look at things, very simple things like, for example, did the applicant sign the form? Because you need to be sure that there is a real applicant. It has happened sometimes that some lawyers have made fictitious applications in the past, so people who died, who no longer existed. So did the applicant sign? Is there an authority form? Is the complaint properly explained? There's a whole this kind of bunch of things. If the case file passes this first test, then there is the second test of looking at what we call the admissibility criteria. And these are Article 34 and 35 of the Convention. And there the criteria are things like, so did Xenia, when she was filing this case, this application before the court, exhaust all the domestic remedies? So did she go through the whole system? Because what did I say in the beginning? The idea is that the national courts are the primary responsibilities for applying the convention. and you have to give the chance to domestic system to right the wrong, if there is a wrong. And so if you don't give a chance to the domestic system, then, and you're bypassing the system, it doesn't work that way. If the court says, you haven't exhausted domestic remedies, then the case is out and everything is finished. There's also a time limit. In the old days, it was 6 months. Now it's 4 months. So you have to come within a certain period of time after you exhaust the domestic remedies. You can't just wake up one morning and say, after 3 years, I'm going to file an application now with my old file. So there is this kind of limitation. And I'm sorry for those of you who are very, probably much worse than this knowledge, but I'm literally looking at Irina, who has her video open, and I'm just saying and talking to her as she's a non-lawyer. And then there are all these other criteria, like, is the right something which is protected by the court, for example, because it has to be within the convention. If it's not a right which is protected by the convention, then we have no competence to examine. Is it against a member state? You know, imagine horrible things happening to you in US, but US is not a member state, so we wouldn't be able to objecate that. There are some exceptions, situations where the court has found responsibility of the member states again, but outside of their territorial jurisdictions. So, for example, when member states like to do adventures in other member states' territories or outside of European legal space, I would say, then we've had such cases like that as well. But just to say, that's the first thing that is done. And we call this, in our internal kitchen lingo, the filtering. So the filtering is done. And what goes up to the units, what I would call the chamber, well-established, etc., is the cases which pass these checklists of the admissibility criteria. And when they come to, they say, okay, we have now a case. Xenia has done an excellent job. All the application form is perfect. All the information is inside. And as well as the fact that admissibility criteria are perfect. And plus, it looks like there's a problem. It looks like there is an issue under the convention. And at that stage, it gets distributed an application number. She gets a letter from us saying, we've received your application. It's registered under this and this. And then she waits a little bit longer afterwards. It depends on against which country it is. But what is the essential thing here is that at that moment, once the case is registered, it is given, apart from a lawyer, which is the lawyer which is going to deal or assist the judge with this case, a judge is also attributed to this case. Okay, and the judge which is attributed is called a judge rapporteur. Okay, so that and it is this judge's role to look into the case file together with the assistance of the judge, of the drafting lawyer, which we call the drafting lawyer, the lawyer who's in charge of the case. They both look at the case file, they both examine the facts, what is there, and make a proposal. And now it depends on whether the case is, and sometimes it could be that at this stage they consider that the case raises no issues, or that something was missed with the admissibility criteria, and it could be declared inadmissible. But it could be, if a case has passed all the stages and looks like there's an issue, there are two ways. If the judge rapporteur considers that the case is well-established case law, which means that the case deals with an issue where, legally speaking, we already have good case law on it, and already when you look at the case file, you already see that there's going to be a violation, more or less. Because it's a case, for example, let's say, it's a very relatively simple case, and the case has lasted 25 years. It's already so obvious and open that there's going to be a violation of length of proceedings in this kind of case, or there is a very open situation of, that's never so open, so I'm going to stick with a very easy length of proceedings. Or sometimes member states have their own problem areas. So areas where member states have issues. For example, Italy has huge number of confiscation cases, confiscation of proceeds from crime. So there is a case law which is established there. Turkey had at some point huge number of cases concerning expropriation. So properties which were taken from people, and then the money was paid so much later, and with the inflation actually, the money they got was really little. So they really sustained the real damage to their right to property. So you have these huge number of cases. And if the case is exactly like that, then the system goes very fast, because this is what we call a well-established case law. And there's a whole procedure where it goes very fast into what we call a judgment, a well-established judgment. And these type of cases are examined by judges, 3 judges. So if you look at the HUDOC, which is our major database, and you find what we call committee decisions, our committee judgments done by three judges, these are the cases which we consider well-established case law. It doesn't necessarily mean that there's going to be a violation, because it could be a well-established case law over no violation, or it could be that it was registered as a well-established case law, but then they realized that the applicant didn't exhaust the domestic remedies, and therefore it's an inadmissibility. But just to give you that idea, and if it's not like that, if it's something which is either new or something more complicated, something which we would consider to be a very particularly tricky area of law, for example, now we're having more and more cases which concern cybercrime, for example. You have more cases concerning social media, whether it's right to private life or whether it's freedom of expression. Because the world is changing, so you have different types of crimes and different types of situations happening. And so if you have a very new case like this, then this is a case which is deemed to be what we call a chamber. Or it could be a case which deals with a very serious case. So, for example, you would find most of the cases which concern violence against women, for example, they would be examined by a chamber. Not only because factually they are more difficult, but also because these are cases which require this kind of 7 judges eye, I would say. So they would be. So you have the chamber cases. How does it work in practice? And I hope that this is still relevant. So please stop me if you think this is irrelevant for your situation. Is it okay? Because, yeah? All right. So how it works is the following. So we said a judge, rapporteur, and a lawyer, they basically sit together, they look at the file, and they prepare a proposal. A proposal, the first stage is a communication. A communication, the judge will propose to the other judges, or if it's a presidential communication to the president, in a format, and you will find these as statement of facts in HUDOC. If you search for communicated cases, you will find them basically saying to the other judges, this is a case, let's say, which concerns gender-based discrimination. The facts are this and this. The applicant has complained about this and this under Article 8, under Article 14. I believe that there's an issue because of this and this. So there's a whole, let's say, an analysis, a short analysis of why the judge considered that this case needs to be communicated to the government. Okay, because before this stage, the government has no idea that there is such a case. Everything before that is not communicated. So, and when it's communicating it, it asks questions. And the questions are based on the article. So the questions would be like, is there a gender-based discrimination in breach of Article 14 in conjunction with Article 8 in this particular case? This and this. And sometimes, in addition to questions, you would also have documents requested, for example. You may consider that you need more information. So you may ask, can you please send us the whole investigation file? Imagine if it's an investigation against some kind of brutality which happened, or an investigation concerning an applicant because they said something online, then you may have some documents, but it may not be complete, so you may ask for more documents. And once it's communicated, then the government has a number of weeks to respond, and they would respond by replying to the questions. And by replying to the questions, they also have the possibility to correct the facts. They may say, for example, it writes like this, but actually it is mostly the reality happened like this. So sometimes you may have in judgments 2 different set of facts, literally, of how the applicant perceives the facts happened and how the government considers the facts happened. And then the court has the unfortunate position of having to kind of establish the facts. These are usually in cases which concern, I must say, right to life, torture, prison conditions, things where you can have different aspects. It's less so for things which are much more material and much more, let's say, commercial or business related. So once the government sends its observations, then it goes to the other side, so to the applicant, and the applicant submits its counter observations. So now, at this stage, the court has a case file, starting from the original application and the two parties' observations. And it is on the basis of this that they decide. So it is important to underline this. So it is based on this case file. Sometimes the cases are big and voluminous, and I've even had cases where the whole room was full of case files. And sometimes it's a very simple, small case file like this. So it really depends on the subject of the case. You can't really, if you're a lucky lawyer, you may have thin files, and if you're an unlucky lawyer, you may have these huge piles of which fall out from the drawers, depending on how much it took place in the domestic level. So on the basis of this, then what happens is the judge rapporteur, again with the lawyer, with the assistance of a lawyer, then they write the judgment, the draft judgment. So that's the initial phase of writing. And when they write the judgment, there's a whole bunch of system in place to make sure that the judgment, the draft judgment, which is there to be submitted to the other judges for discussion, for a vote, is done in accordance with the court's way of doing things, the court's way of reasoning, the court's case law, literally. And this whole procedure is the quality checking. So you have senior registry members, and each section has a deputy registrar and a section registrar. And I've actually even got the names. So for the judges, I said we have 15 female judges, but our vice president is female, Ivana Jelic, and we have 2 section presidents, which are female, out of 5. C'est pas mal. Then for the registrars, however, so for the bureaucratic part, the registrar of the court is female. She's from Greece, Marlena Tisili, and she's the first female registrar of the court. Then we have only 1 section registrar who's female, section 1's registrar, Ilse Freiburg from Austria. But we have 4 deputy female section registrars out of 5. So the next generation is quite luminously coming. And for the jurisconsult department, my boss, the jurisconsult, she's female, she's Irish, and I'm her deputy, and I'm also female. And the filtering department, the head of the filtering department is male, but the deputy is a female. So on the register department, I would say that we are well represented in terms of gender balance. Also because I must say, in terms of the number of people, more female lawyers are there than male lawyers, especially at the beginning of their of the stage. When I came, and then I'm going to make a parenthesis now because to give a bit of a contextualization, when I arrived in 2003, there was only 1 female section registrar. Her name was Sally Dolly. She's like a huge idol for all of us. She was one of my mentors, a huge woman with a very bad temper and would shout at you if amazing, brilliant legal mind. And very towering, big and imposing, but she was literally the only one. And so we would all look up to her, but, it's a different times. And then I think there was, in my view, a conscious policy, to make sure that the female lawyers, also feel more. And I think that was also those of us in the previous generation who really pulled us up a little bit to make sure that we also felt confident enough to apply to higher posts. I remember some discussions we had with some of our senior female registrars at the time, later on. And even with the judges, I must say, when I arrived, it was predominantly male, so 20 years ago. And I remember when not only just predominantly male, but predominantly also quite senior in age. And I remember when the Lithuanian judge, Josiane Danute, arrived to the court and she became pregnant. It was the first time a judge was pregnant in the whole history of the court, and they didn't know what to do for the maternity leave. So they had to apply the rules which apply to the registry members, kind of to give her a maternity leave and everything. So here, a parenthesis of, kind of like an anecdote to say that, despite everything, wherever we are, there's still a lot to go. And we haven't, in some ways, we haven't advanced so much, but nonetheless, okay, now the parenthesis is closed and I go back into my professional explanation of how things work. So what was I saying? So they are there, they're sitting, and there's a whole quality check process. So the senior, if it's a vehicle, so this well-established case law, it's the deputy registrars who do the quality checking. So they check the drafts, so a lawyer drafts, assist with the judge, they get instructions from the judge, and then the deputy registrar checks for compliance with the court's case law, and then it goes then to the other judges, and then they have a whole deliberation on these cases, they discuss, and then they can change things. The deliberation is a very magical place, I would say, where really the judges are full-heartedly in it. They have all read the cases, they all have their own ideas, they all have their own views, and it's sometimes it gives rise to exceptionally heated debates. Sometimes it gives rise to less debates because they all agree on the outcome. So it's a very interesting place to witness. Unfortunately, deliberations are secret, so only a number of people have the privilege of assisting this. But this is important to know. And then, so they go through this. If it's a chamber case, so this is the cases which create case law, which are important, then the procedure is, so there is they draft, it goes to the section registrar, then it goes to the judge again, so judge really looks at it, and at the end, it's in the timetables, and then just before it's going to be examined, about like 2 weeks before, then these files, they come to us, to the jurisconsult department. So my department's role is to ensure the quality and consistency of the court's case law. Okay, so we are entrusted with this, and we have a very broad spectrum of different types of things because we have around 9 units, and all the different units have different roles. So we have, for example, the research department, which is one of the units that I'm responsible for, which is the unit which does these research reports that you see in our judgments. So comparative law, international law research reports, they are done by lawyers who are in the research unit. And they work exclusively for most of the time, 90% of the time, for the Grand Chamber, but also for the Chamber. You have other units there, but the main job, so you have all these units. We have the unit which is called, for example, the knowledge sharing unit, which I hope is the site that you're all using every day. So the ECHRKS website, that's a baby of mine that I feel very particularly attached to. And so that unit, for example, is in charge of that website and everything which goes in there, the updating of the guides and things like that. So the jurisconsult has a very versatile area of action. We're also responsible for the dialogue with the Superior Courts Network on an informal operational level. So it's a very interesting place to be. But our main job, nonetheless, I mean, apart from all of these other units which do this, what we call support to the judges, our main support to the judges is our work on what we call the observation work. And the observation work is that literally we receive these section files. Usually we receive them, I usually read these section files during the weekend, so I have brought now the ones in 2 weeks' time. And the idea is we read them to see whether there are things there which may somehow be contradictory, which may be misrepresented, or which may be very easily, for example, sometimes it happens, you have 5 sections, you have very similar cases, but they may have somehow a contradictory approach. So you need to just warn the judges. Or you may have a situation where there is a Grand Chamber case, and there is a sentence in the middle of a judgment, and that sentence may prejudice the Grand Chamber judgment's deliberations later on. And because we have a very privileged view, because we have this bird's eye view over all the 5 section files, because we receive all the section cases, plus the Grand Chamber, because we're involved, we have this kind of possibility to guide the judges and to kind of give support to the judges in terms of what are the things that may cause issues. But it is a suggestion. It is very diplomatically worded because it is the judges which decide in the end on the judgments. They are the ones who put their names in these judgments, which means that sometimes, and this unfortunately happens and more so, they receive hate mail sometimes, they receive threats. So they do put their necks on the line for this job, one has to say. It's not always all rosy. So they have their names there. So they are responsible for these judgments. And they take this very seriously. It's very important to underline that. And for the rest of us, our job is really to support them in this duty. So for us, when we make the observations, and we usually do them on a Wednesday evening, it is formulated as the chamber may wish to note, they may wish to adjust this, And what is fantastic about the way the court works is that it's a very collaborative way of working. The judges appreciate very much receiving these observations because, and the same when they receive quality check comments from the senior registry members, because it at least theoretically, and I hope they do, but when you revisit your judgments, when you rewrite our judgments, you may find faults with them. But at least on our scale, the idea is really to ensure that you are giving a judgment which is fair, which is in line with human rights law, which is more important, in line with the convention case law, which is the most essential thing for us. So that's the aim, and that is why you have sometimes judgments which are unanimous when where all the judges feel the same, and then you have judgments where the judges dissent because that's also their right, because they feel very strongly about something and they feel that the majority which voted for a particular case did not do a good job in their view, and why. And this is what you will see the chamber judgment. There is another layer, and that's the Grand Chamber. And the Grand Chamber is a composition of 17 judges. They're not a permanent. So for each case which goes to the Grand Chamber, there is a drawing of lots to ensure which judges go up to the Grand Chamber. Section presidents are automatically qualified, so they're always there. But the rest of the judges, it could be anyone. So, I mean, of course, then comes sometimes the issue of, again, we have 15 female judges, how to ensure that there is enough female judges representing in the Grand Chamber level. So there are reflections, I would say. But at the Grand Chamber level, for a case to go to the Grand Chamber, there are two ways. One, either it's referred to directly by one of the parties, so there's a judgment. So Xenia receives a judgment of no violations. She's unhappy about this judgment, and she considers that the judgment that was given by the chamber is actually against the court's case law, or that it creates a huge number of problems, and so she would ask for a referral. And there it's a panel of 5 judges who will sit and which will decide whether or not this case is worthy of Grand Chamber. What is essential is that a case to go to the Grand Chamber, it has to bring something new to the case law. It's not just that you think the judgment was wrong or that you don't agree with the judgment. It has to be something development. Sometimes it's not something new, but it could be, for example, that you feel that the case law is not clear on certain points, or you feel like time is now the time to develop the court's case law. And these are the type of cases that would go up to the Grand Chamber. So, for example, when Kurt versus Austria went up to the Grand Chamber, a case about domestic violence, it was very interesting to see that the Grand Chamber engaged very closely with Grevio and with the Istanbul Convention. Before that, it was merely mentioned, but you understand then behind the scenes. Of course, I don't know why it went to the Grand Chamber. I was not there in the deliberations, but you can assume that there was a wish to develop the court's case law when it came to the state's obligations and how those obligations would be understood vis-a-vis the other international instruments, notably the most important and the close instrument for us, the Istanbul Convention. So these are the kind of things that goes to the Grand Chamber. We have very interesting cases in the Grand Chamber, actually, and the hearings are there. You can watch the hearings online. So if you have time, if you feel interested, don't hesitate. There is one which I think would be particularly interesting for you all, and that's it's ESO versus Spain. Let me just recheck the name. ESO versus Spain. It is. This is a case for which there was a chamber judgment, and now there is a Grand Chamber, and then it went to the Grand Chamber panel, and the panel decided to take it. It's an interesting case because it's all about the patient's informed consent, and what do we understand by informed consent? And in the facts of the case, it's a woman who had breast cancer, and she had to have an operation, and the doctors told her, and she signed a consent form about what she could expect from this operation and what would be the unforeseen things. And when she came out of the operation, thankfully, I think she was cancer-free, but she no longer had nipples because they decided that they also had to take away the nipples. And so she complains about this. She complains about the fact that she considers that she had no knowledge when she was going through the surgery that this could have been one of the unforeseen expansions of the surgery, if I may say. So it's very much related to a female body. It's very much related to the issue of what I give consent to in the context of medical operations and in the medical context, where I think women sometimes, you feel that you're not always fully understood and maybe sometimes dismissed. And now there are real studies which show really that men and women do not react to the same way to the same medications or nor to the same symptoms when it comes to various illnesses, and that most of the time because of this let's say that because the doctors are not well trained to spot this, or they are unable to diagnose in time female patients, and therefore in terms of death or disability, female are disadvantaged in healthcare compared to men. So this is really a real scientific fact. I read a lot about it and years ago, and then I switched all my doctors to female doctors, I must say. But so it's a very interesting case, and I think it's quite relevant for you. There's a chamber judgment where you would find that the court found a violation of Article 8, and the case now went to the Grand Chamber. So we will see whether the Grand Chamber will confirm the chamber judgment or will reverse the chamber judgment. So this is the proceedings in the Grand Chamber. And another way it can go to the Grand Chamber is also through relinquishment. So the member states could also consider that, the chamber could consider that the case is so important that it should immediately be examined at the Grand Chamber level. So, for example, when we had the cases concerning climate change, for the first time, all the cases, there was a couple of cases which came against different countries in different sections. The court relinquished all of them together to the Grand Chamber, so as to have a more coherent, more cohesive judgment. I think I have spoken really a lot. I'm really sorry. I have a number of cases where I thought I'll just talk, but maybe let's give me a kind of like a breathing ground. And if you have any questions regarding this practical aspects of how we do work, then I can answer them for you.
Thank you. Before we open the floor, just to say thank you so much for all this information, as it is very hard to find them in the books. because you have certain rules, but knowing how it really works in practice gives us a totally different layer of your work. And thank you so much for that. So we open the floor, and I don't know if Ksenia, Una, Irina have any specific question.
I don't have specific question. It was very informative and interesting. I wasn't aware of this topic at all. I don't. I mean, as I said, I only know how national courts work and the procedures, and this was very interesting to hear. So thank you from my side as well.
Yes, and you have the option to come to us if you're unhappy with the national practice. So it is. I think it's very important when we are in a small group to speak very informally, and that's why I'm not using my lecture voice and using very formal way of saying things. So that is an advantage. We're a small group, and I hope that since it's not recorded anywhere, if I say anything which is really inappropriate, it won't be out of context. But it is important to know, especially if you are working on this topic, and you do want to see how certain things could be rewritten or what was missed. It is important to see how things really work. And you also, maybe one thing to say is that the workload of the court is enormous. I cannot state, I don't have the statistics with me, but you can look at the website. It is a huge machinery. It is a huge machinery which is trying to fulfill its role with, as I said, very little resources in terms of budget. We are not using artificial intelligence or anything like that. That also I would underline, because sometimes that comes as a question. Our IT department is very conservative for these things, so everything is done by humans. So it's a huge machinery. People are working really with a lot of passion, because the lawyers which are there, obviously it's nice to live in Strasbourg. Obviously you do earn your life well, but everyone is here because they have a certain vocation. That is for sure. And it is the same with the judges as well. There is a certain understanding that you want to do good. You want to do something well. And that is why the approach. But however, one has to understand that this is a court. It is not an NGO. This is very important to understand. That's a major difference. It is not a monitoring body. It is not an advocacy. So which means that it has to comply with rules. And that I really have to underline. Lawyers we get very nice, young, enthusiastic lawyers or interns, and they want to change the world. But you have to tell them there is a case law, there is a reason for a case law, and you have to go that way. And if you want to change the case law, there is a procedure for changing the case law. And it has to be the right case. Otherwise, what it does is that if you, for wrong reasons, if you adopt the wrong judgment, it has a ricochet effect on the real case law. So, if you expand, because you feel sorry for an applicant, then you create a huge uncertainty on other grounds. So it is a court. Make no mistake, it is a court, which means it has to deal like as a court. It has its procedures, it has its limitations. But there is this vocation of looking at things through the lenses of human rights, because that's what the whole convention is about. So you do look at things through those lenses. But it is not an ivory tower. It is not a bunch of people who sit there and who don't know what's happening around the world. It is also people who live there, who are humans. We're not yet, thankfully, bots have not taken over reasoning and things. So which means that, of course, everyone comes with their own experience. And which means, and I think that Ivana, you mentioned this in one of your articles, people, they have their own biases, they have their own historical background, they have their own what they lived through. And it is on the basis of that, of course, that you see the world through those lenses.
Absolutely.
And that does affect, of course, the case law of things. Sometimes, and that is sometimes the beauty of the system, because you have judges who come from very small countries. You have judges who come from very big countries, which has a lot of problems. You have judges which come from richer countries, let's say, with different sort of problems. You have and when they all sit together and they have to explain to each other what certain things mean. And here I will give an anecdote from 20-something years ago. I remember once when we were dealing with, when I first arrived to the court, I was unfortunately tasked with all these cases concerning, there was a huge armed conflict in Turkey. There was a whole situation in the southeast, and you have the cases there. You know, people were disappearing. There was torture. There was also teachers, nurses getting killed by the terrorist organization. So there was a whole bunch of uncertainty, which meant we had horrible cases coming from the southeast of Turkey. And then we had a system, the Turkish authorities at the time, so this is in the early 90s, so some of you probably were not even born by that time, but they devised a system for the villages to protect the villages from the terrorist attacks. They armed other villagers and they gave them the name village guards. Okay, so these guys were basically normal village men, but who knew how to use a gun, and they received money from the state to protect the village from this kind of attacks from organizations. And of course, sometimes these people, they also ended up doing some unlawful things, because they had the statue and they had the guns, so they would, do things. Now, I remember in one of my first cases, and I was writing about this and explaining whether the state is directly responsible or indirectly responsible, because are they acting as a state agent or are they, private persons? So is it the positive obligations and things? And there was one of the judges from who was a rapporteur and who was from a Nordic state. So imagine, from the real Nordic states. And you cannot explain this to this person. She had a real hard time understanding what was happening. Why are these people being, put? Why these people were given guns? And what they're doing. And that is the beauty of the system. You explain, and they were trying to understand. She had to read things on it to understand, but this is the reality, and that's kind of, I would say, the richness of the system, because you really have these people coming from different places. For most of us, it's not our native language. Also, that's also another thing to really take into account. I mean, the official languages of the court are English and French. And apart from those who come from UK and Ireland and France and Belgium and, Monaco, for the rest of us, it's not our native language. And we have to discuss cases, we have to discuss things in a language which is not ours. And sometimes that may also give rise to miscommunication, because you don't have the same refinement. When I speak French, I'm not going to be using the same terminology as a native French person. So it is a very interesting, I would say, experiment is not the right word, because it is a very successful system. And I think that it has done wonders for human rights in Europe and elsewhere, because it is a country which it is a court which is extremely influential with respect to other regional courts in terms of its case law. And in some international monitoring bodies as well, treaty-based bodies. So it is a court which serves its purpose, I would say. And in terms of for you, if you don't have any other questions, do you have any other questions? No questions?
I do. I'm sorry.
Ask me.
I tried to switch on my camera, but for some reason it's not working. So I'm sorry that you can't see me. But I had a question that is more kind of inside info, because you mentioned the possibility of online applications. And that would, I think, make our job so easy, and maybe, of course, yours too. So is this a near future or a distant future?
Sorry, when I said online applications, I made a mistake, and that's my not native language. I meant that you can find the online form on the site.
Oh, okay. Yes, we can find that. Yes.
But I'm sure that we will also work on this later on. I mean, there are a lot of projects on how to make everyone's life easier. Again, this depends on resources and things. But what I wanted to say was that literally that this is that we have an application form online and then you print it out. But sorry about that. That was so. It's good that you clarified that with me, because otherwise you were going to go with an impression that I don't know where this site is. No, that's what I meant. Sorry.
Okay, well, hopefully it will be also online soon. Fingers crossed.
Yes.
I don't have a question, but I would like to express how amused am I what you described. I have never thought that working in a court can be so intriguing and interesting. How you described it, and in a very short period of time, all the layers and how it's done. It's like I respect you so much for you dedicating all your life doing this and still
Thank
being
you.
so inspiration. It's amazing. Thank you so
Yes,
much.
I do enjoy very much my job. I have to say that despite everything that's going around in the world, it is it's good to know. Well, then maybe just I know you're all very tired, but just since I did promise that I will mention very briefly some cases just to intrigue you more, just to some recent cases I've looked around to see what would be of interesting to you. So in terms of for example, one of the cases which I thought was interesting, another Spanish case called Ortega versus Spain. This is a very recent case, December 2025. And it's basically, this is an applicant who worked for a company for many, many years. She was, I think, the head of the finance department, and so she could see what everyone was earning with the payrolls. And what she realized was that she was, although she was at the same position as other men in the company, she was earning less than them, the rest of the heads of departments. So she complained about this internally, and for many years, and because it didn't lead to anywhere, basically, then she complained to the domestic courts. I think it's a specific, now I can't remember which the domestic court she was, but if you look at the facts, I think it's a special court which deals with discrimination. So she complained of discrimination on the basis of sex, and she the domestic courts found for her. She submitted as an evidence these payrolls of how people were earning differently and her various email exchanges. And so the domestic court said, yep, exactly, you were discriminated against on the basis of sex. So she won her case. But then what happened is that she lost her job, because then the company said, these payrolls are confidential personal data. You have used them without the permission of these people. So you have abused your job and authority, and technically speaking, they're not wrong, to use these things in the proceedings, and therefore they dismissed her for basically not doing her job properly. Then she brought again proceedings before the same court that she went, and this time she said that she was basically she lost her job as a retaliation for the discrimination claim that she brought against the state, against this company, sorry. And there, however, the domestic courts dismissed her claim. They considered that she was at fault for sharing these documents, which concern personal data, and that she could have gone about proving her case through other means, that she could have asked for this data later on and stuff. So she lost her case there. She came before our court. She complained of Article 14 in conjunction with Article 8, which is the major discrimination article, as you all know, and Article 8 is right to private life in this context. And the court, first of all, had to see whether or not what she was complaining about enters under Article 8. And there, the court looked at the facts and said, well, she was in the company for 20 years, and after she was dismissed, she was unemployed for 5 years. So there is no doubt that she suffered from this dismissal. And also the dismissal in the manner it was done, because it was based on the fact that she did a very serious misconduct, was something which was a reputation, was a damage to her own reputation and integrity, and therefore there is no doubt that she suffered adverse effects from this, and therefore the case fell within the ambit of Article 8. So the subject matter goes into under Article 8, which makes it possible for us to examine under Article 14, so whether or not there's a discrimination by sex. And there, what was interesting about this case, it's very new, is that the court examined it from the viewpoint of positive obligations and to see whether or not the state had positive obligation in a case like this, whereas basically, because the normal positive obligation on the state, when it's a third party, is like to provide the necessary judicial setting, for example, especially in a case like this where it concerns between two private parties and it concerns a domestic proceedings. But here it said, so the question was whether the state's positive obligation extended to providing protection against allegedly retaliatory measures in the form of dismissal from work following a discrimination claim based on sex. And here the court really underlined the fact that what the Council of Europe's, one of the major goals of the Council of Europe is gender equality, advancement of gender equality. There's a whole bunch of very interesting and very let's say, wording regarding this issue of what does principle of equal treatment mean, how, what should be done in such context. And in the end, it said, for positive obligations under Article 8 requires that they should be real and effective protection against any form of reprisal by employees in connection with complaints brought to ensure respect of the right not to be discriminated against on grounds of sex. So it read into, in this judgment, positive obligations, the extension of saying that not only you have to provide protection against discrimination, etc., but you also have to protect a person against retaliation in the context of gender discrimination. And then it looked at how the things happened in domestic law, and it considered that the domestic law looked good, that there was no problem with the law itself. And then when the law, there's no problem at the law itself, then it goes to look at how it applied in practice to the applicant's situation. So in this case, when it looked at the applicant's situation, and here there are a lot of nuances because there's a lot of factual information which now I'm not going to give you, but it really goes and dissects the manner in which the domestic courts reason, the reasoning of the domestic courts arriving at this non-discrimination result. And there it finds fallacies in its reasoning. So, for example, one of the reasoning of the domestic courts was, well, you complained about sex discrimination for years and years, and you were never dismissed. So this dismissal is really not based on the fact that you complained about this, but rather the fact that you used this. And whereas the court of the European Court of Human Rights says, yes, but when she was complaining before, it was all internal. So it was all internal complaints. And it's only when she started complaining to a domestic court that she was dismissed. So these are the kind of things that it looked into. There are a couple of arguments like this, but I'm not going to go through all of them with you. I want to kind of intrigue you to go and read the judgment itself. And in the end, on the basis of this, the court found unanimously a violation of Article 14 in conjunction with Article 8. That's an interesting recent case. Another interesting recent case is Ellen Others versus France. This is from April 2025. And this is a very sad case of 3 different applications, okay? And all 3 applicants are minor girls. They're girls who are minors at the time of the events, and all 3 instances concern 3 different situations of rape, allegations of rape, okay? The first case concerns a very vulnerable person who has a lot of health issues and mental health issues. And so there are a lot of firefighters who come to the house to, every time she has a health issue, they come to the house. So she has this kind of relationship with firefighters, and she develops a fascination with them. And then in the end, I mean, she's, I think, 13 when the whole thing starts. but she basically sleeps with almost all the fighters, I think, lots of them, of different departments. And these are people who are older, and where, her number is being exchanged between them, like, this is a girl, who likes us, and so go and so forth. It's horrific to read. It's very detailed in the judgment. So that's the first case. And of course, when she, afterwards, her parents, when they realize this, and that she's in this kind of situation, they file a complaint for rape against, especially there are 2-3 of them which are instigators, the main firefighters who are regularly having sex with her, and are kind of inviting others to do the same, let's say. And in these proceedings, in these domestic proceedings, there are a lot of, in the domestic courts, in the end, of course, they decide that there is no rape, because the factual situation don't look like she said no, or that she was coerced, or that there was this and that. And a lot of stereotypical expressions of the judges, moralizing judgments about the fact that she was sleeping around, and and these kind of things. So it's interesting to read. The facts are very detailed. I'm not going to go into that. So that's the first case. Then you have a second case of an applicant who is extremely drunk in a party, and ends up, while intoxicated, having sex with a man, but she's almost unconscious. So this is where the whole issue of, again, becomes problematic, because then the domestic courts consider that, well, she was drunk, and at the same time she didn't say no, she didn't fight back. The guy is someone she knew, they liked each other, blah, 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 and again, no problem. And third case is, again, something very similar, minor child, again, 13, 14. 2 guys pick her up in a car, they take her to a place, and they basically have sex with her without her consent. So it's a horrific set of facts. And the main issue here in these cases is the fact that the domestic system in France at the time, because now they're old, I must say, I can't remember, but I think they are now really working this, and I think they may have just changed the law, but I have to double check. In the domestic law, the consent is not described in the manner which should be described. What is consent? And therefore, the practice of the courts, even though they have developed over time some kind of understanding of consent, nonetheless still does not extend to these situations where a person is really vulnerable, where a person is really in a situation where you cannot genuinely talk of a consent. Apart from the fact that they are minors, but also the fact that, you have vulnerabilities, you have issues regarding, substance use or intoxication, etc. So, to cut the story short, in these cases, the court found a violation of Article 3, which is and Article 8. So it's quite a heavy violation. It's a beautifully drafted judgment, I would say. So really, to read, it's in French. I'm sorry to say, but hopefully there will be a translation. And when it came to the first applicant, where I said the domestic courts were quite patronizing, the public prosecutor and everything, it also found a violation of Article 14, because it considered that there was secondary victimization of the applicant, and that by national authorities of a minor who alleged that she had been subjected to non-consensual sex acts through the use of moralizing and guilt-inducing statements which propagated gender stereotypes. So it found a violation under Article 14 on this basis. Okay, so it's a very interesting judgment to read. I think it's a good judgment for the purposes of, when we deal with these feminist judgments which concern gender-based violence. One very interesting case, surprisingly, these last cases are all against France. I didn't do it on purpose, I promise, but I really want to take different aspects, different themes. So this is about a bunch of prostitutes in France which are complaining about the prohibition in France of purchase of sexual services, because in France they adopted a law where it's not prohibited to be a prostitute. However, if you're getting services from a prostitute, if you're a client, then you can be prosecuted. And so a bunch of prostitutes, they came to the court and they said, this is against our private life because it's against our livelihood. And also criminalizing this act makes it more dangerous for us, because then we end up, having to do this not so openly in various places. The clients, because they run a risk, they also ask more dangerous things. So it's also not very helpful for us, and it's a very dangerous thing for us. So this was their perspective. So it's also very, it's about their own, what they consider to be their own sexual autonomy, their personal autonomy, sexual freedom. That was their point of view. When the court examined this case, and it's a very atypical case because you have, it's very interesting, and I'm always fascinated with these cases where it's, where you have two different sides of the coin and they both make sense, in some ways. And on the other side of the coin was the government saying, I adopted this law because I want to eradicate prostitution, which I find to be somehow against women's rights, against gender equality. I also find that it is it's a propagation of situation for human trafficking, especially trafficking of minors. So and I have put in place a whole system where if a prostitute wants to leave the job, then there's a whole kind of like a social services picking up and doing things, finding a reconversion, etc., etc. So the government's position was, I'm doing this. I mean, on the one hand, these women were saying, this is our sexual freedom, our private life, and we are women, and this is, this is our choice. We want to do this, and you are impeding us. And on the other hand, you had government saying, but this is actually something that I'm doing in a way to further the cause and to make sure that there's no human trafficking, which affects mostly women, and it affects mostly also vulnerable women, immigrant women, and all these things. And in the end of this case, the court found a no violation and it was unanimous no violation. So it considered that and it's a very technical judgment. That's why I'm not going to go into real details, because, for example, in this judgment, there is the comparative law report of seeing how prostitution is regulated in different member states of the Council of Europe. And actually there you find that what the French system is doing is kind of within the minority, but a new trend, which is more the Nordic trend of going towards. So it's a thing. It looked at the proportionality. It looked at how the law was adopted. And it noted that, it was really debated. When they were adopting it, they also got a lot of feedback from different NGOs, unions, which was protecting, so there's a whole part of reasoning in the judgment which gets to this no violation, which is interesting for you to read. And I don't want to go period by period. But in the end, it said that given the current state of development in the domestic law's understanding of the issues raised by prostitution, the French authorities had struck a fair balance between the competing interests involved, and that the respondent state had not overstepped its margin of appreciation. So the court did underline that here we were in a situation of a balancing of rights. Different rights were at stake. And in this balancing exercise, it considered that at the moment, the state did not overstep its role. However, it said the national authorities had a duty to keep under constant review the approach that they had adopted, especially given that it was based on a general and absolute prohibition of the purchase of sexual acts, so as to be able to amend it in line with developments in European societies and international standards in this field, and to adapt to the specific effects in a given situation of the application of this legislation. So it also gave this caveat, okay, you adopted this now and it seems to be working for the moment, but attention, in 10 years' time, if situation changes, that may not be the case. So that's an interesting case for you to also keep in mind. Then we have a number of cases adopted against Poland, which concerned the right to abortion. We have a very long and sad story about abortion, but I'm not going to go into details with this. These two cases, which were recent, ML versus Poland and RA versus Poland, they all concern the situation where at one point in time, the Polish Constitutional Court decided to restrict abortion, especially if it concerned malformations in the fetus, which was previously accepted as one of the grounds for abortion. And, due to certain pressures, I would say the Constitutional Court decided, from now on, it's abolished. And so these two applicants, in two different cases, by the way, they were pregnant. They were pregnant with unfortunately fetuses which had certain malformations. One of them had already abortion planned, and because the Constitutional Court judgment was published, she could no longer have it. From the next day, and so both of them went to the Netherlands to have their abortions. And so when they came back, they complained under Article 8 and 3 about the fact that this judgment on restriction have breached their rights, both under Article 3, which is, as you know, prohibition of ill treatment, and under Article 8, right to private and family life. Under Article 3, the court considered in both specific situations, while understanding that the situation was very distressful for the applicants, it caused a lot of uncertainty whether they could have abortion there or not, and whether they should wait, whether they should go. It nonetheless considered that it didn't reach the threshold of severity which required for Article 3 to come. And this, for example, in ML versus Poland, so the first case, this judgment was adopted, this Article 3 part 423. So it was a very narrow understanding of whether they agreed with the fact that it didn't reach the level of threshold of Article 3. And there was a violation, unanimous violation, I think, on both cases, on violation of Article 8, for reasons which I'm not going to go into detail because it's more on the basis of prescription by law, because the Constitutional Court at the time was a court which was composed in accordance with our case law, not as an independent court and not as a court established by law. So that's why there was a automatic violation there. And maybe just one last one, because I'm sorry, I have a tendency to, when I start, not to finish, but I promise this is last. And surprise, surprise, is against France as well. I'm really sorry, but voila, January 2025, HW versus France. Again, these are weird cases where you realize that actually you think things are really advanced in member states, and then you find archaic laws or archaic practices which still exist, and you are shocked. So this is a case against France, and this is again something which just recently, I think, changed, like literally 2 weeks or 3 weeks ago, on the basis most likely probably because of all of this which was happening, because it made big headlines. So this is a couple, an old couple. I don't remember how old they are, but they're not a young couple. They're not a couple anymore in love. So at some point they stop having sex, okay? And they decide to divorce. And then there's a whole facts of, divorce. There are different types of divorcing by fault, divorcing by no fault, and things like that. And while the first instance court was normal, the appeal court decided to find that the divorce should be by fault, and it was the fault of the woman because the woman was no longer abiding by its conjugal duty to have sex with her husband. Okay, so this is the facts of the case. So just gives you a attempt that I was not aware that this existed, but it existed, and the facts actually take place in 2015, 2018. Okay. And so she complains about this to us, saying that, this is really quite demeaning. It's a violation of my private life. It's also, problematic on various grounds. And of course, the court, when it's examining this case, it's also very nicely written. So I really also suggest that you look at things, but it really talks about, again, consent. Consent is something which is very strongly now underlined in our consent was there also in our early case law. I cannot say that it did not exist. We have MC versus Bulgaria from 2003, for example, which concerned precisely this issue of consent in the case of rape, We have consent in Troquelier versus France, again, early 2000s, concerning the consent to give to medical examinations. However, I have the impression, and this is my personal view, but really in more recent times, I would say, there is a more focus of understanding what consent means and having a more, I would say, well, I don't want to use the word feminist, but yes, having a more, a whole holistic view of what consent is about and having a more realistic understanding of what consent is. And this is again a case about consent and about the fact that you cannot force a woman to have sex with her husband and then decide that then she's at fault for divorcing because she's not having sex, because it's about her own body, it's about her sexual freedoms, and the court is quite strong about that. I'm not going to be able to pronounce it because I have everything in French here, so by the time I translate, I think we will die. But it's very nicely drafted, it's very nicely put, all these things, and if the judgment doesn't exist in English version, there is the legal summaries in English. So go to the legal summary, which will give you the reasoning in nice 2-page format. And of course, you can find all these cases in the knowledge sharing platform as well. So you will be able to follow these cases. But just to show you that you still have these kind of laws that sometimes you think don't exist, but exist. So here, of course, the court found a unanimous violation of Article 8. There was no surprise about that. No one thought that it was weird that it was normal to have such a situation. But you do find these things. We also had a Turkish case, a little bit more older, where again, to divorce, you had to wait like 300 days or something just to make sure that you're not pregnant with another man's baby and everything. And there as well, we found the violation. But just to say that there is a rich jurisprudence of the court. This jurisprudence is rich because of the applicants who bring these cases. So that's also another thing, because if they didn't bring these cases, if this lady didn't bring the case here, we wouldn't have had such a case law. So it's very important for lawyers, and since I have 2 lawyers in front of me, it's important for lawyers to bring cases that they deem are good for the development of court's case law, but also good for their clients. So that's I put this little caveat there. Not that we need lots of more cases, but it's really thanks to the system works because of all of this. It's a system which is intertwined with the applicants, the keep him there. It's beautiful. I don't know whether it's a he, she, by the way, and I assume that's a he. No, it's a she.
It's a she. She is interested in the topic.
It's wonderful. Yes. Well, that's why she's coming in. But so it's really, so you have the whole panoply of actors, and all these actors interact with each other. The government, the applicants, the judges, the international law sphere, the academics. Make no mistake that when academics write an article, the judges read, the registry lawyers read as well, and then you feel like sometimes, of course, I find, there's a comma and there's a whole theory made about that particular sentence, and you're like, no, we didn't go that far, we really didn't think of that like that, but it is a very interesting way to see that it's a system which works with a lot of different actors, and all of them feed the system ultimately. So, for example, an NGO which does a third-party submission to the court, and they provide information that feeds the system. An academic, as I said, who criticize or who considers that this judgment is groundbreaking for various reasons and explains it and dissects it, provides a valuable contribution to the system. It enriches the system. It gives us food for thought, for example, the use of terminology, things that, there are a lot of things moving in areas, and sometimes the court is behind because it's an international court. It doesn't always follow. We still have in the convention the word unsound mind, for example, for mentally disabled people, because the convention was adopted in the 50s, and that was like a normal terminology then, so things move. And so it is a system which works like that. And with this, I'm really going to stop because I have amazingly spoke for about 2 hours. And I was worried I would not be able to engage so long. But I'm very happy, and I really hope that it was useful for your work and that it was useful for the rest of your seminars and lectures. At least it was a pleasure for me to meet young minds. And although I could not see everyone and I could not hear Saiful Islam, I hope that he also profited from this discussion, which I think is quite useful we did talk a lot about gender equality from the perspective of females, but one has to really understand that the system will not be complete if we don't deal with the inequalities there. And actually, it gives you more space. If there is equality, then men have more space, more freedom to explore different things. So it helps everyone, basically. And because we're discussing things male-female, but obviously, when I say that, we should also, I'm not using inclusive language now to make it simpler, because we're in a very particular situation, but I don't mean it in any way in biological terms. So voila. I with that caveat, I stop.
Thank you so much. I really, I'm convinced that everyone enjoyed, Ayşegül, what you shared with us, and I'm really sorry that several students missed the opportunity to listen to you tonight. Okay. I don't know what happened, but in any case, it's Friday afternoon, and I think that we couldn't spend the time better than listening to you. Thank you so much for very insightful information which, as I said, can't be, read very easily. But also thank you so much. And I was writing down all these cases that you mentioned. So I will share
the list.
Students, and that would be perfect. Thank you so much. Because also thank you for the selection of all these cases, and that you underlined the consent and how much it is important in the current jurisprudence. And I know that we also we very much discuss it in other let's say arenas as well. You mentioned this case of Turkey, what is a law on 310 days. But for example, I discovered that the same rule in Thailand, they have still the law, the family law, which basically has exactly the same time. But then when I discuss it in some wider audience, I've heard from a lady from Italy that they have a very similar thing there. So this is why it's really important to have the court and to underline all these practices which we've taught basically that they are dead, that they are non-existent. But it means that it's really important to educate not only lawyers but also other colleagues and to know more about the jurisprudence. At the same time, thank you so much for giving information that can be helpful and may be determined for our students to pick seminar papers or masters, because also all these cases can be dealt in one master piece by itself. So I will just ask lastly, Ksenia, Una, Irina, Saiful, do you have any question, comment?
Okay.
No question, just appreciation. Thank you so much. It was so interesting.
My pleasure. And if you're ever in Strasbourg, please drop me a line.
Maybe we organize a trip to Strasbourg, and then
you should.
We will hopefully meet with you. But in any case, I really hope that you will be open for another lecture, maybe when the semester starts, for a wider audience of students for the International Human Rights Law Group. So we will discuss it. But anyway, thank you so much for having time to meet.
Ivana, I never say no to you. So
I know, and I'm using that. I'm misusing, but it's really great to have friends as you. So have a great weekend and keep in touch. And thank you once again.
Thank you. Bye-bye.
Bye, everyone.
Thank you.
Take care.